planner, she always has to give her license number. So we want to make sure we comply with all the governmental and federal things and rules and regulations.
Two attorneys in a room, and that's never a good idea.
Yeah, I get three opinions, right?
There you go. We were talking last week a little bit. We touched on durable power of attorneys, and again, my lament that the springing power of attorney doesn't exist anymore. But moving on from that, the conversation with the durable power of attorney, when somebody doesn't go through the process of pre-estate planning and pre-need situations and therefore don't have a durable power of attorney, and then one of their loved ones becomes incompetent, I guess the only alternative at that point is guardianship. Is that correct?
Yeah.
And
so, go ahead.
No, I was going to say you practice in that area. Give the audience a little 20 seconds on on guardianship.
Yeah. So, so I'm in front of a judge that says that attorneys can't even give their name in 15 minutes, let alone explanation here. So, basically, with a guardianship situation, that comes into effect when there is no named person to be able to act on a person's behalf if you're incapacitated, or even if there is a power of attorney in place, if the person is acting in such a way as to prevent the agent that's named in the power of attorney to do what's right for the person. So, an agent through the power of attorney can again act on a person's behalf, but they can't remove a person's rights. And so with a guardianship, that is something that is the most restrictive means that the state has to kind of govern somebody, because it's taking a person's constitutional rights away. And so with a guardianship, we are taking a person's rights to marry, to vote, to contract, to drive, and a wide variety of other rights that are being taken away from a person because they don't have capacity to do that anymore. They could be a harm to themselves or others. And so the bottom line is that if there's no power of attorney or healthcare surrogate in place, then that requires us to go to court for this procedure. And that is oftentimes a very strenuous process for both the alleged incapacitated person and also for the family members. And so it's also significantly much more expensive than a power of attorney or a healthcare surrogate, where you can get those for almost nothing or a couple $100s. A guardianship is generally going to cost the alleged incapacitated about $10,000, give or take, for that whole process to complete. So it's much more a good return on investment, talking about financial people, if you're doing this power of attorney or healthcare surrogate up front, rather than having to wait for a guardianship to do all this stuff.
I find in the conferences I do, and again, I do very minimal, so don't step on your toes on these estate planning, but the occasional conferences I have, first of all, I hate those conferences. I am like everybody else, not wanting to discuss all of the bad things that will ultimately happen, but they're necessary, and everybody who's listening should give David a call, or at least some estate planning attorney. It is very important to go through the discomfort of discussing the what ifs, because people come to me and they say, okay, well, we just want a simple will. We just want it to, when I die, I want to go to them. Well, what happens if they die before you? Oh, well, what happens if the kid dies before you? Oh, I hadn't thought about that. Mm-hmm. And all of a sudden in the estate planning conference, we're fleshing out all of the different, very sad and unfortunate scenarios that we hope will not play out, but you have to account for them if you're going to do your job, David, and if I'm doing my job, and if people are being honest with themselves, they need to really think about what they want to happen when bad things happen. Mm-hmm. And the durable power of attorney is an incredibly useful, powerful document that prevents the need for this guardianship. And I didn't realize, I knew it was expensive and I knew it was a very stressful procedure, but I didn't know it was quite that costly. And what I did know is every time the guardian wants to do anything on behalf of the ward, the incapacitated, they have to go to court to get authority to do just about everything. Right. So suddenly you want to do something, you're going in front of a judge again instead of just acting on their behalf. So it's very important that those of you who are listening consider your estate plan. And although we call this elder law, this is not necessarily for the elderly. As David, you pointed out, the living wills, I didn't realize that either, that the court cases were all women under 40. But a living will, for those of you who don't know, is that pre-declaration that you either do or do not want to be kept artificially alive. I'll let you explain it better than I can.
So a living will creates a rebuttable presumption as to what you want to have done or not done for your end-of-life procedures. And so it's different from a do not resuscitate order that a lot of people think is the same. A DNR or DNRO is something that is only provided to you by your physician. And it's a yellow piece of paper, and it's really only for CPR or for paramedics to come in to do something or not do something. And so a living will is going to allow you to state, first off, what you want done or not done for your end of life, specifically if you're in a terminal condition, end-stage condition, or persistent vegetative state, and then we kind of go beyond some of those basic categories. And also, what you want to have done for your anatomical gifts, for example, if you want to donate your tissues and organs, and who you want to name to carry out these decisions. And one of the hardest things for people to even contemplate is the idea that somebody else has to make the decision to use a colloquial term, pull the plug. We really don't want to do that. So the living will allows us to say what we want to have done rather than to force a family member to have to make that really difficult decision.
We've been talking about guardianship, and this has come up several times. When you do have guardianship, does that mean you have to be with the person 24/7?
No. So we've had some guardians that are remote in different states or countries even, and usually you can have other individuals or companies handling a lot of the local care, and so long as the guardian meets other state requirements, then it should be no problem for the guardian to be a remote individual.
Let's go into Medicaid, because that is the big thing now when people might have to go into assisted living and maybe there's not a lot of money left to support them in assisted living. But if you go in for, what would you call that, a Medicaid discussion or an elder care financing discussion, you need to get on. You can explain it more than I can.
Sure.
So go ahead and explain why Medicaid might be important to know about for your planning.
So my particular practice, we only deal with two very specific Medicaid services that are provided to the elderly. Medicaid covers a wide area of services that are both federal and state funded, but we handle only the what's called institutional care program, or the what used to be known as the waiver program, which is the home and community-based services program, and that's for people that are either living at home or in an assisted living facility. And so what happens is when the person goes into a skilled nursing facility, which is a nice way of saying a nursing home, then that costs about $10,000 a month, give or take. And the problem is that either you are going to be independently wealthy and be able to cover that $10,000 a month on your own, or you've got long-term care insurance. Those are the only two ways that you can really cover it without the government getting involved. And the third way is having Medicaid basically cover much of that cost. And so the reality is that, while some people may not want to consider Medicaid because it's a government program or whatnot, 99% of individuals in a skilled nursing facility are utilizing the Medicaid system at that point because it's very expensive. You're talking over the course of a typical what I would call lifespan in a skilled facility is about 2.5 years, and so that's easy at $10,000 a month. You're talking about a $250,000 that you're spending just for room and board. It doesn't cover medications, supplies, or anything else like that. So Medicaid is a useful tool, and we like to call it asset preservation. We're basically looking at a person's assets, and to qualify for Medicaid, there's certain very strict requirements regarding a person's age, level of need, and whatnot. And we usually, as the attorneys, can only help with the asset side and the income side. So there's certain tests that have to be met. And so a person's income has to meet certain criteria every year. Kind of the law changes. Right now it's about 2105 is the gross income that a person can have, and about $2,000 in assets that a person can have in non-exempt assets. And so most people may say, well, I've got more than that, and so they won't meet the Medicaid criteria to get these services. And we can help reallocate the assets in such a way to allow for them to be able to be eligible for Medicaid. And this is all done according to the Medicaid rules. So we're not trying to hide money or do anything else like that. It's something that is permissible, and we have good relationships with the DCF attorneys and work with them to ensure that everything is done above board, and we're making sure that we're providing services to really help the individual in need, not necessarily just to make sure that there's money for other people left over.
That brings us right into this question. My sick spouse is in a skilled nursing facility, and I have been told that I have to spend down all of my assets before I can get Medicaid. Is that true? How will I care for myself?
Right. So the beauty of the Medicaid system in this respect is that a spouse has different financial limitations than the applicant or the recipient of the Medicaid services. So, while the recipient of Medicaid has a certain limited income of about $2,105 in 2017 for what they can get as gross income, a community spouse can have unlimited income and can have assets in excess of, in 2017 again, because it changes every year, of about $120,000. So, so you can, and then of course there's certain spousal diversions that can be had for a certain amount of the applicants or recipients' income to go towards the community spouse. So again, it's important to talk to an attorney versed in this to know what kind of criteria and rules are available.
Right. One question that comes up in my real estate practice frequently, and I always refer them out because I don't know the answer, has to do with what I've heard as the look-back period.
Right.
So I guess I'll let you explain the look-back period better than I can bungle it up.
So now the look-back period is a 5-year period that basically is for any gifting or other transfer of assets. And that includes putting money into an irrevocable trust that'll incur a look-back period or any gifting. So, one example that I have is a gentleman that was caring for his spouse that he knew needed to get Medicaid. And so he gave a bunch of money to his church, about $25,000, in anticipation of applying for Medicaid. But the problem was that we had to report that $25,000, and that became a penalty. And so the penalty doesn't incur when you give the gift, but it occurs when you actually apply for Medicaid. And so then there's a divisor that kind of changes on a yearly basis as to how much of a penalty period you're going to have based on the amount of money that you have given during the look-back period. And so, there's again, we don't have enough time to go over all of it.
We can't go all of it, but again, bringing it back around to the real estate, because that's my area of practice and what the show tends to focus on, is how it affects real estate. And again, I'll have parents come to me and, in this pre-planning need, and they'll maybe want to gift it to their children or adding
a child to the property as a gift.
So that is deemed a gift, and therefore wouldn't, unless 5 years passes, it would become a problem during the look-back period with application with Medicaid. Yeah,
because Medicaid says that anything that's done like that is whether or not it was intended to be so. It's a quote, in anticipation of applying for Medicaid, whether or not you really planned for that to happen or not. You may not plan it 4 years out. You may not really think about that, but it so happens. So sometimes we need to get an affidavit from the attorney saying, no, that was actually not done in anticipation of Medicaid, and then it could be okay. But there's a lot of things that can come up like that.
That's another reason why they should start planning now and getting all of these different trusts and everything lined up, because they don't know what in 5 years is going to happen. You need to line it up now.
Right.
So you don't have to worry about that.
The punchline is, don't put off the estate planning conference. It may be uncomfortable, but it's absolutely necessary, and a very important part of life is dealing with these afterlife circumstances.
Yeah. Mm-hmm.
One more time, give out your information, Mr. Slonim.
Sure. It's, my name is David Slonim. The law firm is the Slonim Law Firm, and the web address is slonimlaw.com, and that's SLONIM. And the phone number is 321-757-5701.
Says on your card here, assisting families since 2005 in estate planning, probate, Medicaid planning, guardianship, digital estate management. We covered a lot of things in the last 2 weeks, and we hope you'll come in next week, and we're going to be discussing more real estate involvement. Jonathan, give out your information as well.
All right, Lack and Lack Charter can be reached at area code 321-953-5115 or on the web at lacklaw.com.
Thank